Today's Legal on 4, legal options when it comes to mental health treatment. We're not talking about an elderly person here with dementia or an individual with a disability. We're talking about serious mental health issues where families may need to look at legal options to protect a loved one from themselves or others. Our legal contributor Craig Wisnam is here, and first off, explain to us what is meant by a serious mental health issue.
Well, it takes many different forms, but it's generally something that would be defined psychiatrically or psychologically as a mental disorder, something that seriously impacts the way an individual can interact, and is generally something that's been chronic and persistent and been a continuing problem. Although, and it has, dementia in certain forms can manifest in a way that's similar. Even things like infections and brain damage can sometimes lead to similar things in terms of the practical results. But still, we're talking about things that come under mental health issues.
Okay. I guess it was this year that Arizona enacted a law to help with this?
Well, they've refined the law. They have had for some time, although it's relatively recent in terms of how we deal with these things, what's called a mental health care power of attorney.
Right.
And it's something that every individual may want to have in place, just not knowing what may come down the road. But it's especially important for people who've had a history of these issues. It allows someone to consent for their mental health care treatment. Even it can include what we call level 1 mental health care treatment, which is generally a facility like Keno.
A commitment sort of
exactly, where they can commit someone to give them the treatment that's deemed to be necessary.
So this authorizes the person that has signed it to do all these things. Exactly.
It's a voluntary advanced planning technique where they know, gee, I may be in a situation where my medication's no longer effective or I'm off it, and I want my mother or my sister or my spouse to be able to authorize this for me with minimizing court interaction.
Well, this is a lot of responsibility for that person.
It is, but keep in mind it's something that will only be triggered if an appropriate mental health care professional, a psychiatrist or something like that, indicates that this is necessary. So it doesn't allow someone to just lock you up because they feel like it.
What would happen if a person didn't have this mental health power of attorney?
Well, it depends how acute the need is. One other option is our normal guardianship proceedings in Arizona can allow someone to have, in certain situations, mental health care powers, where they would have basically the same authorization we're talking about under a mental health care power to seek mental health care treatment, and especially, if necessary, to seek that level 1 commitment. And that's a very specialized guardianship. Most of your run-of-the-mill taking care of mom or aunt proceedings don't include that, and the court has to feel it's really going to be necessary, and they have to have a psychiatrist or someone similar indicate that.
And tell us about the Title 36 procedure.
That might be looked at as maybe the most immediate in the last course. That's essentially the commitment proceeding for a person to get level 1 treatment if they don't have any other options, if they don't have a mental health care power. And it can be started in different ways. The most emergent situations would be where people call the police and they determine that this person appears to have such a serious mental health care issue that they're going to be a danger to themselves or others. They can, take someone like that to a facility like Keno. It can also be something that Southern Arizona Mental Health Care Corporation, SAMHAC, which is essentially our organization that deals with that, has what they call a MAC team, Mobile Acute Crisis, where they will send someone out to evaluate if they have this kind of immediate need. Either they're a danger to themselves or others, or in slightly less emergent situations, if they're persistently disabled because of their mental disorder, as they define it.
You said you found that this might be a good idea for some, your older family members that might have some issues, but would this be done at the same time as a medical power of attorney?
Generally, yes. I can tell you that we include it as part of that document for most people. Again,
you may never need it, but...
Exactly. There's probably no downside to having it in there. And for most people, it's very unlikely it will be necessary. But you sometimes, as people get older, or they have some sort of situation where these symptoms arise, and you think it would be easier to treat them if they had it.
Okay. Thank you so much, Craig. Appreciate it.